Hi, welcome back. I hope you're all well. Thank you so much for watching the recent videos I've done on predators and how to spot them. They're doing really well, and I'm glad people are getting something out of that. A slight change of scenery. I have discussed before defense of one's home and how we have extra powers in terms of stopping an intruder from getting into our house, or if we should find an intruder in our house. But what if that person trying to get in your house is a police officer? That is one of the most searched terms on the internet. Do the police have the power to come into your house without a warrant? And it's actually quite a surprising answer. Most people would think it was no. You see a lot of people in comment sections saying they can never come in, and they have to have a warrant. It's got to be signed in wet ink and all this kind of stuff. Although the law does protect your home, and you've probably heard the phrase from English common law, a Englishman's home is his castle, it does also give some exemptions to that the police can use to come into your house without a warrant. Why do I talk about this? Well, it's not to assist criminals, as in the videos I've done before when dealing with police. This is to help people that are not criminals understand what their rights are, because sometimes mistakes are made. I've actually been involved in a situation like this myself. When I was with my girlfriend many years ago now, the police sort of talked their way into her house, and I didn't really get involved in that because we had not long been together, so it was really up to her to make the decision as to whether to let them in or not. And they kind of duped her into letting them in. There had been a fake allegation made by her ex, who had an axe to grind. He wasn't very happy with her, so he had made some insinuations. The police had turned up. It certainly wasn't enough for them to get a warrant, but they were able to utilize some of this stuff to kind of talk their way in. And looking back at that, they should not have been allowed in at all. And you might think, well, why shouldn't you let the police in? Well, actually, we have rights in this country, and I think it's fair that people don't just come into your house uninvited, especially if they're looking to go through your things or make judgments about you. That is a line in the sand for most of us. So I think it's important to understand exactly what our rights are in these circumstances. So as I mentioned, I'm going to read some stuff off the screen next to me here. That's why I'm looking away. But as I mentioned, in general, the police do not have a power to come into your house uninvited. So if you invite them in, they can come in. You can uninvite them. Now, I've had this situation as well. I was in a situation again with that girlfriend, again, the same situation. The ex has, made some allegations which were untrue, but the police obviously have to come and do their due diligence. And they turned up, asked to come in the house. We let them in because at the time we didn't have anything to hide, and we wanted to discuss this to kind of nip it in the bud and stop it from going any further, get them to understand that this was an ongoing problem that had happened a couple of times before. And actually, the police, when they were in the house, became fairly unpleasant. They started talking fairly unpleasantly to the children and kind of lecturing us a little bit. They, didn't like the attitude that I had, and I asked them to leave. They basically told me at that point that they wouldn't leave, and I said, you absolutely will leave. I'm withdrawing your permission to be in the house, and you are now trespassing, and I will use reasonable force to remove you if you don't remove yourselves. At which point they did leave, and they were very annoyed about that. That didn't do me many favours at the time, but just so people understand that can be withdrawn. If you invite someone in, you can withdraw that just as you would a member of the public that is acting unpleasantly in your house. You don't have to continue to allow them to be in there. Anyway, that's by the by. If you haven't invited them in, what are the exemptions that they can use to actually come into your house? So this is all set out in PACE. Section 17 of PACE, which is the main no warrant power, this is the one that is most frequently used, allows a constable to enter and search any premises for the purpose of executing an arrest warrant, arresting a person for an indictable offence. So this would mean that they can search for that person. It doesn't mean they can carry a full-on search of your house. They can't start going through all your drawers. They would be able to look in places where it's possible a person could hide. So a small drawer obviously can contain a human being, so there's no reason that they should be looking through any of that. And I would strongly recommend that you record what's going on in the house, because if they do start going through your personal belongings, you could actually have a civil action over that, because they are looking for a person, not a thing. So this happens quite often, that they may have a belief that a person is hiding out in a house and there is an arrest warrant for that person. It's an indictable offence. You can look up indictable offence versus something less serious like a summary only offence. Those are the sort of things tried in magistrates court, and they don't permit warrantless entry. So things like minor traffic offences, small scale criminal damage, common assault. You know, if someone had been doing 35 in a 30 and they happen to have come around your house for a glass of wine one evening, that doesn't mean the police can kind of force their way in to serve that person with a speeding ticket or whatever. It would have to be an indictable offence. And as I say, that can sometimes be mistaken, that police could have some sort of information that maybe you're related to that person. For example, I've had friends this has happened to, where police have turned up and they believe that someone's cousin, you know, may be hiding out in the house, and actually these people have nothing to do with that family member. They haven't seen them for several years, and you can understand why the connection is being made. But nonetheless, you know, the police can use this Section 17 power to actually come and have a look around the premises for that person. So don't be mistaken there. If you try and stop them from coming in and they have really good reason to believe that a person is in there and they've committed an indictable offence, there's an arrest warrant for them, then you're not in a position to stop them coming in. But just be aware they cannot search everything in your house whilst they're doing that. They can also use Section 17 to come in to prevent serious harm, stop a breach of the peace, or saving life and limb. So those actually cover quite a vast volume of ground when you think about it. Preventing serious harm, they have utilised that in the past quite questionably. One of the things they talk about, and this is probably the most abused part of this section, is they're going to undertake a welfare check. If you answer the door, they might say something along the lines of, you don't seem yourself, you seem like you're not quite right. You know, they allude to the fact that the person might have some sort of mental issue, and then they use this Section 17 to say that they need to come in and conduct a welfare check. And actually the courts have addressed this directly and unambiguously. The court ruled that concern for welfare is not sufficient to justify an entry within the terms of Section 17. It is altogether too low of a test. Parliament set the threshold at the height indicated by Section 17 1E because it is a serious matter for a citizen to have his house entered against his will, and by police officers. Parliament having set that level, it is important that it is met in any particular case. So this means police cannot force entry because you are refusing to speak to them. That's often the reason given. They have to do a welfare check because the person that they think is in the house won't speak to them. Because they assume you are dead, that's not a good enough reason either. Because you've had an argument with your wife, or to carry out a safe and welfare or general well-being check. Now, there is a caveat to that, that if they believe you've had an argument with your wife and they believe that she may come to serious harm, then they would enter under the guise of stopping serious harm coming to someone, which is perfectly understandable. There have been many compensation cases on this. To illustrate the point, Ravi, a London-based IT professional, had never been in trouble with the police, answered his door. He asked officers what they wanted and why they wanted to enter. An officer put his foot in the door. Metropolitan Police ultimately paid £14,000 in compensation after a court found the entry was unlawful. The officers had misused Section 17 to conduct what was in fact a welfare check, which the law explicitly does not permit. So they can't just come in to see if you're okay. They can ask you if you're okay, they can ask for your permission to come in and talk to you and ascertain if you're okay, but they don't have a power under section 17 of PACE to do that. Stopping a breach of the peace is obviously another interesting one that could be quite wide-ranging. This is the sort of thing where you may see like a utilities company trying to gain entry to a house to, you know, change someone's gas supply. They haven't been paying their gas and they want to put in a meter, for example. I've seen this happen quite often, and they call the police to come along because the people within the house don't want to let them in and they're stopping them from getting through. The situation in that case is slightly ambiguous because they often have these strange kind of warrants that haven't been signed properly, that haven't come from like what I would say a judge in a court that signed off a warrant. They're kind of printed out in these centres, and I am not at all sure on the situation there, whether those warrants you would have to let them in or not. They're not the police, you know, they're a private entity, so it seems more like it's a civil situation. The police will turn up to support them sometimes, and they will use this section 17 regarding we're going to prevent a breach of the peace. Now that could mean that something's happening right now and they say, okay, there's like a big fight going on or there's pushing going on and we're going to stop that. That's a breach of the peace. We're going to enter the property to make sure that doesn't happen. But more concerning is that they can think there's going to be a breach of the peace, and that could be enough to utilise section 17, that they basically say we had real concerns because the people weren't letting these guys in to do their job, and we thought, you know, from the raised voices that there could be a situation, so we decided to go in and prevent a breach of the peace. And obviously when the police go in and do that, that then gives the other guys entry through an open doorway. So it's a bit of a game that's being played there, but a breach of the peace could cover many things. You could be playing music really loud and upsetting everyone. You could be having a party and lots of people are kind of coming in and out of the house and causing some aggro in the garden or whatever. There could be many reasons that the police utilise this section 17 in terms of breach of the peace. Saving life and limb is fairly self-explanatory. Obviously something very serious would be going on for them to utilise that. I don't believe that is abused too often, because they would need to show, you know, they would need to evidence that they had some reason to believe that was happening, and that would mean some serious stuff was going on, and it's probably warranted that they have entry at that point. If someone is in danger of losing their life, then we pretty much need the police to go in and do something about it. So I don't think we have too much of an argument there. Then we have some other sections of PACE that come into play. Section 18 of PACE. Now this is another one that I've had experience with myself. When I worked in security, as I've mentioned before, I got arrested quite a few times just for dealing with horrible people. You know, that there would be an altercation, we would deal with the guy, restrain him. That would be obviously a fight situation because people don't want to be restrained or removed from clubs, and there would be allegations made both ways. The police would turn up and they would arrest us all. That was quite common. I got arrested many times, more times than I can care to remember, and on many of those times my house was searched under section 18 of PACE. I'm pretty sure that most of those shouldn't have happened, you know, and I was young at the time, I didn't know much about this stuff. But section 18 of PACE is what happens after a suspect has been taken into custody. This post-arrest power allows police to search premises occupied or controlled by a person who is under arrest for an indictable offence if they have reasonable grounds for suspecting evidence is present. Now, given that I would have been suspected at the time of, let's say it was an ABH, because I'd been fighting with this guy trying to restrain him and he had been injured, that I wonder what they would be looking for in the house. You know, you can understand it if it was a drug dealer, for example. They would obviously want to search the house in case he had stashed his drugs there, he's got evidence there, scales, whatever. Or, you know, someone who had committed like a series of assaults on women. He might have some kind of kit at his house, some rope, some duct tape, whatever he was using, some chloroform. I don't know what these people would use, but you get the idea that there's obviously a necessity to do that if someone's been arrested for certain things. But it did make me think, well, what were they searching my house for? And they actually took some very unusual items out of my house. One of the things they actually took was something they thought was a modern type of body armor, and it was actually like a canvas bag that I used for transporting a computer around. You know, back in the day I used to play on a PC with other friends, like have a LAN connection with them, so you could kind of wire up these PCs and play. We were playing stuff like Doom, you know. Now you would just play it online, but back then you had to wire it all up. So we would want to take our computers around to each other's houses, and they took this bag away saying it was some kind of body armor, which isn't even illegal to have body armor. Even if it was body armor, there's absolutely nothing wrong with owning that. So, you know, really, really strange. I think they were just being a kind of pain to me, because they really didn't like me at the time, because of course they kept arresting me and I kept walking, because they shouldn't have been arresting me. I hadn't actually, you know, if they'd used common sense in those situations, they would have seen the guy that I dealt with in the club was, you know, had a criminal record as long as your arm, was deeply unpleasant. There were multiple witnesses saying that this guy was a troublemaker. He had started problems and then he had started fighting with the door staff, and naturally we had to deal with them. And you can't tickle these guys to remove them from the club. You know, it takes a little bit more pressure than that. So it might be something that's warranted. In a couple of the cases I experienced it wasn't, but just be aware obviously that if you're arrested, even if you haven't actually done anything but you're arrested, there's no proof yet that you've done it, they can search your house under section 18. Section 32 of PACE, search at time of arrest. So the power under section 32 is only available at the time the individual is arrested or immediately after. It is not permissible for police to return to premises to search them several hours after the arrest. So case law has established that delays of even a few hours for a section 32 are unacceptable. So this might be where they've actually arrested you at your property or just outside your property, and they immediately go in there and search it, you know, whilst that's happening. What they wouldn't be able to do is arrest you on the other side of the country and then kind of turn up at your house hours later to search it. That would fall within a section 18 type of search, I'm guessing. They would have to apply for that. Breach of the peace, common law power. So breach of the peace we've kind of discussed. It's a common law concept rather than a statute. Police have a common law power to enter a property to stop an ongoing breach of the peace, or to prevent one they reasonably believe is imminent. So that's where I discussed the kind of concern that I had over that's really up to them to kind of verbalise how and why they thought it was imminent, and it would be hard to argue against, because they could say, we heard raised voices, and unless you're recording everything on audio, you probably couldn't prove otherwise. So that's a pretty carte blanche power when you think about it, if they wanted to misuse that. And once a breach of the peace has ended, the police no longer have the power to remain on the premises. So given that the police legitimately believe they have power under one of those sections to enter, and they knock on your door, what must they do in order to gain entry still, legally speaking? And the case law in O'Loughlin versus Chief Constable of Essex makes crystal clear that officers must tell an occupier of private premises the real reason why entry is required, thereby permitting an opportunity of voluntary admission unless circumstances make it impossible, impractical, or undesirable to give the reason. PACE Code B mandates that officers must be courteous and no more intrusive than necessary. Officers must explain who they are and why they are there. So they can't just turn up and then kind of push their way in and not tell you anything. There may be some really extreme circumstances, like it said here, it's impossible, impractical, or undesirable. So it would be very, very unusual that they were unable to articulate why they wanted entry into your house. They should be able to tell you under which section they're coming in and why, and who they are. Because these days, you know, it's not beyond belief that someone could obtain a police uniform online. There's plenty of stuff sold second hand. So I would be quite wary of a guy dressed like a police officer that just rocked up at my house and kind of pushed his way through the door, didn't say anything. This has reflections of what happened at Manchester Airport, where the guys actually got off with one of their charges because the police failed to identify themselves before they set about the guy and tried to grab him and restrain him. And he argued in court that he didn't even know who they were, you know, and by the time he had started fighting, it was kind of too late to realise who it was. The same could be said here. If the police just push their way into your house, you have no way of knowing if they're legitimate. They could be corrupt. A policeman could have gone mental that day. That's not beyond belief. They have a very high stress job. So the law doesn't allow for them to just randomly push their way in. If they had a warrant, they would be showing you the warrant, etc. There should always be something articulated. You have a right to read any warrant carefully before you let officers inside. You can refuse entry in most situations unless they have a warrant or specific legal power, which we've just discussed, those legal powers. Police must use reasonable force only when the law specifically permits entry. You can file formal complaints if officers break these rules or abuse their powers. If the occupier is not on the premises, police are lawfully required to leave a visible written notice explaining their reason for entry. A copy of any warrant must be left at the property at the time of entry. If not, this can render a lawful entry unlawful. Critically, if you believe your home has been searched unfairly or without authority, you can raise a formal complaint with the Independent Office for Police Conduct or seek advice from a solicitor. If a search was conducted unlawfully, evidence gathered may be challenged in court. So this is really important in terms of evidence, that if they mess up any parts of this search, so they failed to say why they're there, or they didn't leave the warrant paperwork, then they went and searched your property, found a load of stuff and pulled it out. I've seen this happen before, that those items are no longer admissible in court. And they could be really damning items, you know, that would absolutely ruin you in the case that's against you, but they literally get thrown out. They're not allowed to be admissible in court, and that's a massive problem for the police if they're doing stuff like that. So where are the clear limits? Well, the police cannot force entry because you are refusing to speak to them. They cannot assume you are in danger because you had a domestic argument. They cannot enter or carry out a welfare check or well-being check. And having entered to save a life under Section 17, they cannot then imprison you and search your house. Police powers of entry are not unlimited. Officers can only search areas relevant to the purpose of their visit. If they are looking for stolen property, they cannot go through personal letters or unrelated electronic files. Unreasonable or excessive searches may breach your rights under Article 8 of the Human Rights Act 1998. So I've also experienced this, you know, that they've gone through lots and lots of things in the house, and it wasn't even relevant to the reason that they said they were at the house in the first place. So you have to be careful of that as well. As I mentioned before, if they were searching for a person and they start looking in drawers and tiny little cupboards, you would have to question that, you know, because a person isn't going to be found in a kitchen drawer, for example. The gap between what the law actually says and what officers routinely claim in practice is substantial and well documented, unfortunately. The welfare check misuse of Section 17 is described by a specialist police misconduct solicitor as almost daily misconduct. Courts have awarded compensation to victims for unlawful entry. The public has almost no idea the word Section 17 shouted through letterbox does not automatically mean the police have a right to break your door down. So there's very specific parameters that they should be acting on in order to gain entry to your property. Obviously, if they have a warrant, they should be showing you that warrant. I hope you all found that useful. Like I said, this isn't a guide for criminals. Criminals know all this stuff anyway, believe me. I'm not telling them anything they wouldn't already know. This information is just for the innocent people that have fallen foul of the system for whatever reason. It does happen more often than you probably think, unfortunately. So I really hope this gives people some decent information on what should and shouldn't be happening. Thanks for watching. Take care. I'll catch you all next time.